Attorney Steven Bertolino wants to be dismissed out of the Petito versus Laundrie lawsuit. Why? Because in this motion to dismiss, which I will go over with you, he's claiming, one, that the statement was just an expression of hopes and prayers, two, that the statement is privileged under the attorney-client relationship, three, that he has absolute immunity because the statement was issued under the litigation privilege, and four, because there is no law, there's no prior case, no precedent in Florida that allows an attorney to be sued by a non-party, a non-client, for statements that they made in the attorney-client relationship. So we're going to take a look. I'm going to walk you through the motion to dismiss, point out some things that are interesting. Does the statement amount to outrageous conduct? Bertolino claims it doesn't. Therefore, the court should dismiss him out of the lawsuit. So, hi there, I'm Michele Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I've done a lot of videos on the Petito versus Laundrie lawsuit, which I think is very interesting. And people need to pay attention to this lawsuit because I think, in my opinion, this judge is going to dismiss, is not going to grant, I should say, not going to grant Bertolino's motion to dismiss. I also think the judge is also not going to grant the Laundries' second motion to dismiss the complaint, to dismiss the lawsuit. So let's start out by taking a look at this statement that was made by Steve Bertolino on behalf of the Laundries. So we're going to look at the statement that he issued. I'm going to take you to Exhibit A. Literally, it's Exhibit A. It's on Steven Bertolino's letterhead, September 14th. I'll read it to you for those of you who are listening. And again, this video is for education and information purposes only. And it's simply my analysis, simply my opinion. So please do leave a comment with your analysis or a question. And please do support my channel by subscribing. And thank you to all of those of you who have subscribed to Michele's analysis. Okay, so here's the letter on Steven Bertolino, the attorney from New York, the attorney who represented Brian Laundrie and represents the Laundrie family, who was just added as a defendant in the Petito versus Laundrie lawsuit, where Gabby's parents are suing Brian's parents for emotional distress, for failing to provide information. They're alleging, Gabby's parents are alleging, that Brian Laundrie told his parents, Christopher and Roberta Laundrie, that he had killed Gabby Petito, and that this statement that was issued, Gabby's parents are claiming, was false and misleading, causing them emotional distress. Therefore, the Laundries and their attorney, Steven Bertolino, should be held liable, responsible for the emotional distress that was caused to Gabby's parents. So here's the statement. Here's one of the reasons why Gabby Petito's parents are claiming that the Laundries and their attorney, Steven Bertolino, caused them emotional distress. September 14th, statement from counsel for the Laundrie family. This is understandably an extremely difficult time for both the Petito family and the Laundrie family. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that a search for Miss Petito is successful and that Miss Petito is reunited with her family. On the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. So again, it is our hope that a search for Miss Petito is successful and that Miss Petito is reunited with her family. So Gabby's parents are claiming that this language, this statement, was false and misleading and caused them emotional distress. Steven Bertolino, the attorney for Brian Laundrie and the Laundries, is claiming that no, that statement is just an expression of our hopes and prayers. It's not malicious. It wasn't with reckless disregard. Therefore, they are not responsible. neither Steve Bertolino or the Laundries are responsible for emotional distress suffered by Gabby's parents. So let's see what Steven Bertolino says in his motion to dismiss. Let's analyze. Yes, he's a newly included party because he lost. They lost. The Laundries lost their request to not have Bertolino added as a defendant, to not allow the Gabby's parents to amend their complaint to add Bertolino. They didn't prevail on that. So Steven Bertolino, their attorney, is now named as a defendant and potentially liable for emotional distress damages to Gabby Petito's parents. So what Steven Bertolino is saying, hey, I'm an attorney here at all times relevant in the cause of action. I was acting as an agent for Christopher Laundrie and Roberta Laundrie. Why is that important that he's claiming he's an attorney? Because he's going to claim that the statement was privileged and part of the attorney-client relationship, which is protected. He's also claiming that Gabby's parents didn't identify any facts or circumstances or conduct which were undertaken outside the attorney-client relationship. Well, I think Gabby's parents are going to claim that that statement was not protected by the attorney-client privilege because the statement is false or misleading. And here's where Bertolino says, to the contrary, the two specific statements which I read to you attributed to Mr. Bertolino reflect hope and prayer. Yeah, they may reflect, they say hope, they may reflect hope, prayer's not mentioned, but they may reflect hope and prayer, but the question is whether or not it was truthful. Were those words truthful or misleading? Gabby's parents claim that they were malicious or with reckless disregard, causing them emotional distress. So Steve Bertolino claims that statement was an expression of hope and prayer. The second reason is there's no established legal precedent within Florida which sets forth the proposition that a lawyer can be sued by a non-client for expressions of hope and prayers under any circumstance or in any context. Okay, that may be true, but the fact that there's no prior case law doesn't mean that you don't have a lawsuit. Doesn't mean that you don't have a cause of action. Again, this is a motion to dismiss, so it's a low standard. The judge is just looking at whether the facts alleged in the complaint arise to a cause of action for emotional distress. Steven Bertolino is claiming here that no, they don't, because it's an expression of hope and prayer. Doesn't show there was no allegation of malicious or no facts to support it was malicious. The statement was malicious or reckless. I assume Gabby's parents will disagree with that. Okay, so there's no allegation identifying when this purported information, and the purported information is that Gabby's parents allege in their complaint, in their lawsuit, that Brian Laundrie advised his parents that he had killed Gabby Petito. Based on that, the statement they're claiming, Gabby's parents are claiming, the statement was false and misleading because it talks about the search, our hope is the search is successful and that you will be reunited. Well, I'm sure Gabby's parents are going to argue. And again, this is a tragedy for both families. They lost their children here. But I'm sure Gabby's parents will be arguing that that statement was false and misleading because they had information about where Gabby was. Now, there's no allegation identifying when this purported information was made known to Mr. Bertolino or whether such was known by Attorney Bertolino. Of course, what Mr. Bertolino knew or did not know could not be known to the plaintiffs and can never be known based upon the attorney-client privilege, which exists between Mr. Bertolino and his clients, the Laundries. So right there, Bertolino is claiming it's protected under the attorney-client. They're not going to be able to find out whether or not Bertolino knew that Brian had killed Gabby Petito, whether or not the Laundries knew, whether or not Bertolino knew the Laundries knew, all of that he's claiming will be protected under the attorney-client privilege. And why that's important is because I'm sure that's what they're going to be asserting that privilege during the depositions when the Laundries and Bertolinos are asked these questions. But at this stage, at a motion to dismiss, the judge isn't going to be ruling on whether or not the attorney-client privilege applies and whether or not it's true. The judge is just looking at whether the four corners of that lawsuit, that complaint, the amended complaint where they added Steven Bertolino, whether there's enough information in there, enough of the allegations to support a cause of action against Steven Bertolino. Okay, so with that said, Bertolino says, whatever Mr. Bertolino's knowledge was or was not, the statement was neither misleading nor inaccurate. Well, we don't know that yet because we don't know the other information that I'm sure will come out. The Laundries haven't been asked these questions in their depositions. They haven't had the depositions yet. But that is the crux of this case, whether or not that statement was true or not. Gabby's parents are arguing it was false because they're claiming that the Laundries knew and Steven Bertolino knew that Brian had killed Gabby Petito. Whether or not that's true or not, at this point, the judge isn't going to be making that determination. The judge is just deciding whether there's enough facts alleged to support a cause of action for intentional infliction of emotional distress. Then they go on, Bertolino goes on to cite in his motion to dismiss a bunch of case law. None of the examples, the prior cases, involve an attorney acting on behalf of his client, and none of them involve any expression of hope or prayer. And again, Bertolino is arguing it's an expression of hope and prayer. Gabby's parents are arguing it's a false statement, okay? So what's interesting here, which I think is very interesting and creative by Bertolino, is this statement here where he says none of the examples provided, so none of the prior cases, suggest that a cause of action for intentional infliction of emotional distress could possibly exist in a situation where no conduct or statement occurs. So I think what Bertolino is creatively arguing here is that that statement doesn't arise to conduct. Now, the Laundries tried to argue that the statement doesn't rise to speech. The judge found that that was speech, and whether or not that speech is outrageous or reckless is enough to support a cause of action for emotional distress. Whether or not it's true or not, the judge doesn't make that determination. It's whether or not there's enough information to support a cause of action. But Bertolino is arguing here that that statement doesn't arise to conduct. Therefore, it cannot constitute the outrageous conduct required for emotional distress lawsuit. And here's where they talked about the jury instruction. Whether that extreme or outrageous conduct was a legal cause of the severe emotional distress. Now, case law or the jury instruction talks about outrageous conduct. Now, I think making a statement does constitute conduct, but we'll see what the judge decides. And again, the judge is not determining whether or not the conduct was outrageous, just whether or not there's enough information to support a cause of action for emotional distress. Okay, then Bertolino says there's no material facts in the complaint that alleges that he acted with intent to cause severe emotional distress. Well, the problem with that is the standard is not whether Bertolino had the intent to cause severe emotional distress. It's not a subjective standard, it's an objective standard, meaning would the reasonable person, based hearing those words, that statement, think that Bertolino or find that Bertolino acted with reckless disregard or with malice. So that's interesting. Now, this case is not going to be easy for either side, and whether or not it even gets to a jury, we don't know yet. They still have to have depositions, find out if there's other information, get that privilege log between the any communications between the Laundries and their attorney. Judge has to rule whether the attorney-client privilege applies, whether this absolute immunity applies. That's down the road. At this point, it's just the judge is making a call as to whether or not Bertolino should be dismissed out of the lawsuit at this point. In my opinion, I think this motion to dismiss is going to be denied. Okay, so let's move on here. Bertolino says, even if the court were to find that the conduct was outrageous and extreme, it is privileged. Why? Because Bertolino was doing nothing more than acting as an attorney, and It was actively involved in an acute legal situation. Therefore, Bertolino has absolute privilege. This relates to what's called the litigation privilege. So statements that counsel make during litigation in the courtroom, regarding the lawsuit, it can be argued to be privileged, and therefore the speaker, in this case, Bertolino, would have absolute immunity. But I'm sure Gabby's parents are going to be arguing, wait a minute, there was no lawsuit at the time the statement was made, that the search was successful, that you will be reunited with Miss Petito. There was no lawsuit pending at that time. Whether or not there's an investigation, or whether or not an investigation would be under the umbrella of a litigation privilege, a judge down the line will make that determination, but not at this point. And again, Bertolino is claiming it was a benign statement made on behalf of his clients. Let's see. It's difficult to imagine. This is interesting. It's difficult to imagine how the Laundries, through their attorney, Mr. Bertolino, could possibly have picked the right words to say under these circumstances. Interesting. Pick the right words. Well, I'm sure Gabby's parents are going to be arguing they weren't the right words because they weren't even true. So, I don't know that this amounts to a defense. And again, the judge isn't going to be making the call on the defense at this point. Bertolino goes on to say, while there's certainly no evidence to suggest that the September 19th was anything more than heartfelt, I think that was the one relating to prayers. No matter how poorly received it was, or even could have been received by the plaintiffs, it would never rise to the level of creating a cause of action. Well, again, that's a factual dispute. That's up to a jury, if it goes to jury, for a jury or a judge to decide. And Bertolino claims that failing to advise or failing to disclose the death of Miss Petito, the failure to provide information or to issue a statement is not a basis for outrageous conduct. Well, Gabby's parents disagree. That's why Bertolino and the Laundries are being sued. If you do provide the information, it has to be truthful. Okay? So what is it? We don't know whether or not the Laundries knew that Brian had killed Gabby. We don't know if Steven Bertolino knew that at the time the statement was made. So again, they go on to say, the lawyers should be protected because they were doing their best for their client. And they claim here the lawyer of an unpopular client is placed in a difficult situation in terms of what to say or not to say, in an attempt to stem the tide of negative public discourse. I get it. The media, all the public scrutiny that was going on, Bertolino and the Laundries decided to issue a statement. But words matter. When you make the statement, was it outrageous? What did they know? Was it outrageous? Was it reckless to make that statement, assuming they knew that Brian had murdered Gabby Petito? Clearly, the Laundries, through their attorney, had a legal right to say something. Yes, they have a right to say something. And when they say something, it has to be truthful and not misleading. To suggest that the Laundrie family was not legally permitted to make the statements would require this court to create new law, and in particular, new law that absolutely conflicts with the Laundries' constitutional rights. And again, this goes back to, the Laundries have a right to remain silent. Back to that motion to dismiss that the Laundries made initially on the first complaint, the judge ruled that this statement does constitute speech, and this statement could support a cause of action for emotional distress. Now, the Laundries and Bertolino had every right not to say anything, but when they spoke, words matter, okay? And the fact that the court is, it makes a decision on this and decides somewhere down the line that the statement is not protected, well, that could set new case law. Okay, but the judge at this point in motion to dismiss is not making that determination. All right, so last thing. In conclusion, the four corners, and that's all that the judge looks at, the four corners of the complaint, whether or not there's a viable cause of action against Mr. Bertolino under Florida law. Not whether or not the allegations are true or not, but whether or not There's enough in that complaint to establish a cause of action against Bertolino. And in my opinion, I think the judge is going to deny this motion to dismiss. And I think there is enough information in that complaint at this point for a viable cause of action. I don't know at this point. It's too early to determine whether or not the case will even make it to a jury or survive a motion, for summary judgment down the line. The purported conduct at issue is not outrageous. Well, again, that's a factual dispute. The statements at issue were benign on its face and not made with any intent to cause the plaintiff's harm. The expression of hope and prayers was not reckless. And again, that's how Bertolino is characterizing the statement, as an expression of hope and prayer, where Gabby's parents are saying, no, it's evidence of emotional distress. There was no affirmative duty for Mr. Bertolino to provide plaintiffs with any information. That's true. He could have remained silent. But when you make a statement, the statement has to be accurate, has to be truthful, and has to not cause, according to Florida law, not cause emotional distress to Gabby's parents. As the Laundries' attorney, Mr. Bertolino acted with a privileged context. Again, a judge has to make a determination down the road whether or not the attorney-client privilege would also protect the statement made by Bertolino. A lawyer in Mr. Bertolino's position cannot be sued for issuing the types of statements described in the second amended complaint. Well, we don't know that yet. To allow such a lawsuit would always make silence the safer option. Well, silence is an option, but also different words could have been issued in that statement. They didn't have to state the words that they stated. So you don't have to go to extremes here. You can issue something that's more benign or less, not all the statements that they made. To allow such a lawsuit would always make silence a safer option, even when silence may be harmful to his or her client. Yes, silence could be seen as harmful, but when you make a statement, words matter. And when those statements cause harm, a defendant could potentially be found liable for emotional distress. Dismissing the claims against Mr. Bertolino is not a rejection of plaintiff's grief, and it does not diminish the devastating loss they suffered. Dismissing the claims against Mr. Bertolino is simply what the law requires. Again, in my opinion, I do not think the judge is going to grant this motion to dismiss. Therefore, Steven Bertolino is not going to be dismissed out of this lawsuit, in my opinion. I mean, silence was an option, but when they issued this statement and said these words, "It's our hope that the search is successful," that could certainly be argued, disputed what that statement says. Search is successful. Well, could Gabby's parents argue, if Gabby is dead, is the search successful? And Miss Petito is reunited. Can she be reunited if she's dead? It's a terrible tragedy for both families. But, at this point, for this purpose of this video, the question is whether or not the judge is going to grant this motion to dismiss. And in my opinion, and again, this is simply my opinion, I don't think the judge is going to grant this motion to dismiss. So, what's your analysis? What's your opinion? Do you think the judge will grant this motion to dismiss and that Steven Bertolino will be dismissed out of the lawsuit? Please let me know what's your analysis. Leave a comment, leave a question, and please do support my channel by subscribing. And thank you to all of those of you who have subscribed to Michele's analysis. And thanks again for watching.